short introduction. Christoph Moosbauer said something about the law of the sea. I cannot underline everything you said, I must say. Also about the sources of international law, but I won't go into detail at this point. So let me start very far in the past. Maybe it's worth recalling in this audience that the earliest legal reflection on the status of maritime waters at all were actually made with respect to exactly the belt of waters facing what is today Israel and Lebanon. Some 3,000 years ago, a certain Veneman, priest of Amun at Karnak, was sent on a commercial mission along the Phoenician coast. His extensive travel diary not only tells us of a robbery at the ancient city of Dor and the hostile reception he received in Byblos, the so-called Report of Veneman, a very famous document, also opens the very first chapter of the history of the law of the sea. It is firmly declared in this document that the sea is no legitimate object of human aspirations, but rather falls exclusively within the godly domain. 1,000 years later, a similar attitude prevailed among Roman writers, and the Bible too abstained from attributing any maritime waters to anybody, let alone from drawing precise lines, boundary lines in the sea. In view of the controversies and difficulties which still today arise from the biblical perception of the land of Israel, one cannot but say, fortunately enough. In the meantime, man has obviously challenged these godly prerogatives vis-à-vis the sea, as he did in so many other domains. Modern international law, as codified in the 1982 United Nations Law of the Sea Convention, which you mentioned already, allows for states to claim certain areas of the sea to come under their sovereignty or to exercise therein certain sovereign rights. A rather fine difference linguistically, but an important one in legal and practical terms. Probably most of you know that Unclos is has developed into a quasi-universal code. The number of state parties has risen to 162, and the list of outsiders being in constant decline. Even the US, and you will see it down there, once probably the fiercest opponent of the convention, has made a complete volte-face. Today, the official position of the United States, and it is again in these days before the Foreign Affairs Committee in the Senate, the official position of the United States government is joining the Law of the Sea Convention as a top priority for the United States. So we all know that several states in the Mediterranean have some problems with this convention, in particular Turkey, and I do not have to comment on this. I already talked with you yesterday evening. I don't know exactly the reason for Israel of abstaining, but there are none in my, but you will tell us something about this later maybe. But this convention has a high attractivity, but now starts the magic of international law. The magic of international law. The Unclos rules, and this is not disputed anymore, at least those concerning the delimitation and distribution of ocean spaces for various purposes, have undoubtedly become part of customary international law and are as such binding upon all states, whether or not they decide to formally adhere to the convention. So it doesn't matter whether Israel becomes a member of the party to this convention. The rules contained therein are binding upon Israel. Actual or alleged transgressions of states, when states transgress the mostly invisible lines in the sea, may entail the same consequences as a violation of land boundaries. In the worst case, such a transgression may indeed constitute a casus belli. Two recent examples which you all know. One may recall the two one in to recent incident in or above legal uncertain waters. We've brought the protagonist at the edge of war. I do not have to comment upon them. Maybe the right one is not so very well known. 5 years ago, the incident in the waters off the Iraq-Iran coast in the Shatt al-Arab, where British soldiers, Royal Navy members were seized by Iranian coast guards. In waters having actually been politically and legally calm for decades or even centuries, tensions may suddenly arise and erupt and rise particularly high when natural resources come into play. Another two recent examples. Warmongering rhetorics are an alarming signal for a possible escalation. The South China Sea, nobody cared for decades or centuries about this region, the Spratly Islands. If these countries, but now we see in the Global Times of China a statement like this, a recent statement of last year's, if these countries, the other coastal states in the area, don't want to change their ways with China, they will need to prepare for the sounded cannon. What was the reason? The discovery of oil and gas in the area. You see this triangles, there's the black triangles. And indeed, as the second example shows now, that from mere threats to war, it may be a very small step. Some years ago, 10 years ago, already 15 years ago, before the western coast of Africa, you see it up there, between Cameroon and Nigeria, there was a kind of war, the occupation of a peninsula, following the discovery of oil resources. For 200 years, nobody cared about this area, but now everything changed. This case, however, is also a good example that international law and international dispute settlement mechanisms do provide adequate means for a peaceful solution even of most intricate situations. The ICJ in this case delivered a final judgment in 2002, and under the auspices of the United Nations and with the guidance of the United Nations, Nigeria returned the occupied Bakassi Peninsula to its rightful owner, the Republic of Cameroon. What Unclos is in the very end all about is to avoid such kind of escalation. Yeah? The recent decision on maritime delimitation in the Black Sea, Romania, Ukraine, is another positive example in this respect. This conflict again was triggered by rich oil finds. Let's have a close look at the preamble of the United Nations Convention on the Law of the Sea, which makes unambiguously clear that the primary aim and purpose of Unclos is exactly this: to provide the two essential ingredients for a peaceful settlement of all sea-related disputes between states. That is a comprehensive set of legal routes, first on substantive law and second on procedure. No doubt there's an intimate link with the purposes of the United Nations, and a wanted link. So, one of the most important substantive rules is contained in Article 56. Now generally recognized, but at the time certainly one of the most innovative elements of the Convention, is that states have sovereign rights for the purpose of exploring and exploiting their natural resources in a strip of water adjacent to their coast. But let me again recall at this point, the EEZ is no state territory. With respect to this maritime zone, similar to the continental shelf, Unclos pursues a limited right-oriented, not a space-oriented approach. Now, if you have a somewhat closer look at the area at stake, this is your map. I'm sorry, you will see it again in the next presentation. I'm sorry. We will see that it is certainly not the law of the sea which is to blame for the difficulties we encountered at present. I'm an international law. I'm defending my my field of studies and research, which is to blame for the we encountered regarding the distribution of waters in this part of the Mediterranean. The great number of stakeholders in the area may be a challenge in this respect, but they are no obstacle for a just and lawful delimitation in the area. What complicates the situation is not the law, but are the complicated by a number of political circumstances, which I cannot even enumerate in this brief introductory statement. But let us have a very brief look at the stakeholders. We have Egypt. We have Gaza with a question mark, which may be a major issue in the future. We have certainly Israel. We have Lebanon. We have Syria. We have Turkey. North Cyprus with a question mark. I'm sorry for our Turkish colleagues, but I have to put a question mark. We have Cyprus, and then something which is often neglected. We have the special base areas of Great Britain and Cyprus. So if we have a look at this, we might say, how can we make a delimitation in this area with all these entities, political entities? It might be very difficult. But I will just return to the Unclos Convention, which puts states, in particular in such a situation, under a particular obligation to cooperation. Article 123 of the Unclos Convention provides in this respect. States bordering an enclosed or semi-enclosed sea, the Mediterranean is such, in accordance with Article 122, now the lawyer comes out, should cooperate with each other in the exercise of their rights and in the performance of their duties under this convention. 2 points which I cannot even touch upon. I will concentrate on a particular issue, you can imagine which one. I will just briefly touch upon 2 points which will be of much importance in the future in this area. There's first the future maritime boundaries of the state of Palestine. They have to be this has to be added to the list of open questions. You see the Oslo Agreement left, so this is a very delicate, I will not comment on it, but if you see the oil finds on the right, you will see the maritime territory of a future Palestine will have an impact on the solution, or has to be taken into account. The second issue, oh, sorry, wrong direction. Oh, sorry. The second issue, certainly, this is Cyprus. I won't go into the details of Cyprus because this will take us hours, and I have another 5 minutes, I guess. So, but what you will see there is, you see down there, this is the these are the norms in the Great Britain-Cyprus Treaty of 1960. The Republic of Cyprus shall not claim as part of its territorial sea waters lying between line 1 and 2. These are the terminal points of the, oh, I have a pointer there. This, and lines 3 and 4. Okay. So there may be a future dispute. I talked with you about this yesterday. If this provision concerns only the territorial sea of Cyprus or even other maritime zones, yeah, such as the continental shelf, or I'm not aware about any discussion on this issue, but it may come up in the future, and maybe we find some oil exploration companies from Great Britain just off the Israeli shore as well. So Europe is directly involved as well. Maybe, we know, who knows? But let's return on solid legal grounds. The 1982 Convention provides a coherent and comprehensive set of legal rules. We have the 200 miles rule, which however, obviously in the area, given the geographical circumstances, is not of much help in the region at stake. Nor will we come even close to a sea of 400 nautical miles, which would allow for states to unilaterally determine the outer limit of the EEZ. Thus, what's needed is a consensus between states concerned. And also for this scenario, certainly, because it's a comprehensive convention, the UN Convention has a solution. This is a key provision for the solution of maritime disputes regarding the EEZ. Very closely. The ideal solution laid down in para 1 is a bilateral bi- and trilateral talks between states and the eventual conclusion of a respective delimitation treaty in search of an equitable solution. If this is not feasible at the moment, states are under a legal obligation to enter into so-called interim agreements. Look at para 3. Yeah? And if states directly concerned do not come to terms, for whatever reasons, political reasons mainly, or economical reason, there's only one alternative, a sole alternative, the recourse to peaceful means of dispute settlement. See para 2. Let me be very clear on this point. The peaceful settlement is not just an option for states. States are under a legal obligation to recur to such means of their own choosing, however. So I just introduced the term equitable solution. This is a big problem for the jurisprudence. I could give a lecture for 3 hours on this issue, but just make very, very short. An equitable solution, according to the settled jurisprudence of international courts and tribunals, starts with a provisional drawing of an equidistance line. Second, one should consider whether there are relevant factors calling for the adjustment of or shifting of that line in order to achieve an equitable result. But I can be very short on this point. Given the geographical and other circumstances in the situation at stake, the figuration of the coast here is rather unspectacular. No adjustments seem to be necessary, and no adjustments were made also in the treaties concluded between certain states. So there briefly mentioned, we have the treaties we have. Those treaties are binding. Those treaties are binding. The treaty between Cyprus and Egypt, the earliest one. The driving force in the area is Cyprus, the pioneering role. Probably it is correct that this state took the initiative because they are not so much involved in all these difficulties, which I will not comment upon. But Cyprus has concluded a treaty with Egypt concerning a line. Oh, sorry. May I ask you to move this way? No, perfect. Thank you very much. The Cyprus-Egypt line is continuing here. We have a Cyprus-Lebanon agreement of 2007, which is supposed to continue this line up here, which is, however, unratified. It was not ratified by the Lebanese parliament and is, as such, not binding upon Lebanon. And then we have finally the Cyprus-Israel agreement of 2010, which entered into force last year. It is a binding agreement upon both states. Oh, sorry. Oh, my God. Oh, whoa, whoa. Wrong. Okay. Sorry. Okay, it's a binding agreement. What I have printed you there is a standard clause in all those treaties, a necessary clause, the so-called third-party rule. It is an emanation of the principle of the sovereignty of states and the equality between them, that any two states may not with legal effect agree on issues to the detriment of a third state. Unilateral declarations of states of unilateral declarations or even treaties are as thus just statements of the law. They are not binding on third states. The definition thus of tri-points common to more than two states necessitates the consent of all states concerned. And here starts the problem. 2 minutes. Okay, I have only 3 slides. Now, we have no delimitation line between Israel and Lebanon. And it's difficult to imagine that we will have one in the near future, given the political circumstances. When states do not talk with each other, what do? They recur to, unfortunately also in this area, to strong rhetorics. We have it on the Israeli side, and we find the same rhetorics on the side of Lebanon. Fortunately enough, both states soon returned to legal argument. Unfortunately, this did not happen in a dialogue, but rather in a monologue. In accordance with Article 74 of the United Nations Unclos, both states deposited lists of coordinates and charts with the United Nations. Unfortunately, they are contradictory. I will not comment on the methodology used by Israel to draw this line, which is disputable, which is highly disputable. I will leave this out. But I will just return to the protest note of Lebanon vis-à-vis the Israeli line of delimitation. And Lebanon accuses Israel to flagrantly violating its sovereignty, its territorial sovereignty, in drawing this line, in particular the terminal point. They recur to a very old document, the Paulet-Newcomb Agreement of 1923, because one of the tenets of international maritime law is that the land dominates the sea. Rights to maritime claims always derives from sovereignty over its adjacent land territory and the extent of this territory. And here starts the problem. Where is the starting point on the Israeli-Lebanon coast? And the 1949 agreement, now we have, this is a very last slide, but it's quite important. Now we have a small difference between Israel and Lebanon. We have a difference on the coast at point 31 on the coast, the red dot, of 22 meters. Israel is claiming 22 meters more to the far to the north than Lebanon does. One might say this is a quantité négligeable, but it results to 16 kilometers at the outer edge of the continental, of the EEZ. This amounts to 860 square kilometers, probably full of natural resources. No negligible quantity at all. So the legal options, you have no legal options. This is the final slide. Okay, what is needed in the area is an agreement, interim agreement between all states concerned. If Lebanon is not able to talk to Israel, they have to use methods foreseen in the Unclos Convention. They have to look for the good offices of the United Nations. But nevertheless, there's no alternative to a final peaceful settlement in the area. Thank you very much. Sorry for going to...